in the benefit of the children. Thank you, Mr. Chair.
Honourable David Cunliffe.
Thank you very much, Mr. Chairman. Mr. Chairman, Part 2 relates to a number of important provisions in the bill, most notably the ability of the Commissioner to depart from formula assessment, collection penalties and relief. It takes us through automatic deductions. It sets out the grounds for penalties. It does, as our colleagues have just noted, reduce the maximum rate of penalties after a period of time in an effort to prevent people becoming locked out of the system, and it provides more discretionary relief from penalties. So, Sir, what I wish to do is to firstly take the House through some of those penalty provisions and then to turn to several of the more operational matters which follow from that and go to the heart of the Department's capacity to deliver on this bill, such that it is. Mr. Speaker, the bill does allow the Commissioner the ability to write off penalties, and that is important because during my last call I noted that the accumulation of child support debt has now grown to a colossal $2.3 billion. Now, about $1.6 billion of that is accumulated penalties. And the tragedy is that the penalty regime really has needed an overhaul for some time. Because in practical terms, what happens is that liable parents, usually dads who are estranged from the family, can get behind, particularly if they're low income or unemployed. They then incur penalties which make the problem worse. They get to the point where they cannot afford to catch up, but there has been no provision in the law for the Department to write those off or down to bring parents back into the system. And I know of constituency cases where those parents have fled the country because they have seen themselves and been seen as outlaws because they've been unable to get square with the ledger of their child support arrears, and the penalties have mounted up too fast. So, although the Labour opposition votes against this bill, we do not support the bill. It's got some fatal flaws. It doesn't put the children first. It is a missed opportunity. But, Sir, we do agree with this provision, or these provisions, which provide more flexibility in the penalties, such as Clause 36, which allows the Commissioner to write off incurred incremental penalties when a payment agreement has been completed. So there's a positive incentive to bring people together to reach a voluntary agreement on catch-up, and it gives the Commissioner the ability to support that by a reduction of historic penalties. Secondly, penalties incurred by receiving clauses, the charging of penalties due to overpayment of child support, i.e. irregular payments. You might pay too early or too late. Somebody pays a double amount one month, but then they incur a penalty because they're late the next month. This gives the ability to the Commissioner to smooth that through and avoid an unintended consequence. It also provides an ability to include the provision for the Commissioner to write off some or all child support payable to the Crown if the receiving carer was a social security beneficiary or recovery would place the liable parent or the children in serious hardship or represent an inefficient use of the Department's resources, and I will come back to that matter in a second. But in general, Sir, much as we don't agree with the bill as a whole, we do agree that these penalty provisions make sense and will go some way to providing positive incentives for people to get together and act in the interests of the children. And that has been the core theme of our opposition to the bill the whole way through. Now, here's a couple of things buried within that part, Sir, that we don't think are constructive. The first is the reversal of the onus of proof on automatic deductions. Sir, currently you have to, or somebody has to opt in to say that they want a direct deduction or an automatic payment of their child support liabilities. Now, this bill changes that, and it says that they have to opt out. And that throws up some very serious privacy and natural justice issues. As my colleague Dr. Clark has said, just suppose somebody doesn't want their employer to know their family circumstances. Perhaps jobs are under threat and they don't want the employer to know that their family is split, Mr. Chairman,
Honourable David Cunliffe.
Mr. Chairman, and that their partner has moved away, because that might make their employment situation more vulnerable. Maybe it is more complicated than that. People lead complicated lives sometimes, and they're entitled to make judgments about what's in the best interests of themselves, their families and their children, including whether they disclose those circumstances to their employer. Now, to be fair, there is an opt-out provision, but we believe that the reversal of this burden of proof is flying in the face of natural justice processes and creates a whole swag of additional red tape. Mr. Speaker, that then raises the next issue, which is the costs of administration. Inland Revenue reports, I understand, that it's expecting a 15% increase in the workload associated with administering what is already, and I quote, Inland Revenue's most expensive product to administer on a per-person basis, because necessarily it's bespoke, it's fairly customised. The complexity of the formula, the ability for more variation in the payment systems, which I've just said we think is a reasonable thing, will inevitably increase the cost burden on the department. And here's the kicker: it will put more burden on the adequacy of the department's computer systems. Now, for those perhaps like the Attorney-General who are getting a little bit of after-dinner shut-eye, they may not have noticed, Minister, that the department's computer system is creaking. It's good to see the Attorney, after a hard day watching the Supreme Court, is now leaping to his feet in defence of the department, because it may be that his department, the Crown Law, will be called upon to adjudicate matters that arise. Oh, we won, did we, Minister? Oh, we won. Well, what about New Zealand winning? Because I'm afraid, Minister, if you flog off our energy system, New Zealanders will be the loser.
I think I can anticipate the point of order. I know. No, I'm on my feet, and let me just say, I know that the member responded to an interjection, and we all need to be above that. Let's come back to the bill.
Mr. Speaker, you provide an excellent example, and I shall earnestly try to follow it, Mr. Speaker. Mr. Speaker, the department recommends that it needs a rebuild of its computer system, and the price tag thereof would be about $1.2 billion. In fact, as much as half the accumulated child support debt, which is a lot of money, sir. And I don't know how any person or entity could actually spend $1.2 billion on a computer system, because that sounds like an awful lot of money to an MP from West Auckland. But what I do know, sir, is if you have a computer system that is, I thought that would get the itinerant member from Mount Albert. She wishes, the casualty of the maestro of Mount Albert, getting her excited, Mr. Speaker. Mr. Speaker, $1.2 billion for a computer system, sir, makes one wonder how long the IRD's mainframe is going to stand up at all, and whether it can cope with the additional burden of more customised child support. So just wrapping that bit up, sir, let us first concur that the increased flexibility on penalty payments is a good thing, that the additional customisation costs, the additional work around automatic deductions, the reversal of the bonus of proof, the increased costs of administration, and the grave danger that it will not in any case be able to be implemented by the department's creaking computer systems, that all adds weight to the opposition's conclusion that we cannot support the passage of this bill in its current form. And, sir, concluding my remarks, one must come back to the point that this really is a missed opportunity. It has been common ground across the House for a number of years now that the child support regime needed a fix. and we supported this bill to select committee, sir, the Labour opposition. We were ready for the debate, for the calling of submissions. We worked earnestly with the government to try to find a way through this. We regret, sir, that we are unable to support the bill at this stage, but, sir, the issues of transparency, of accountability, of cost, of the burden of proof, of the lack of the primacy of the interests of the child have all driven us to that conclusion.
Mr. Chairman.
Melissa Lee.
Thank you, Mr. Chair. It is a pleasure to rise to follow